Good morning, Judge Glacier. I know we're a couple minutes early, but we do have both parties as well as the court reporter ready whenever you are.
Okay, I'm ready.
I will bring the
Good morning, Mr. Ellison.
Good morning. Oh, there we go.
Good morning.
I'm all set.
Good. Is it Ms. Zilgit? Pronounce it for me.
Zilgit.
Zilgit. Good morning.
Good morning.
Nice to meet you.
Nice to meet you.
We'll just wait. I want to make sure our court reporter is ready.
Yep, I'm trying to bring them in, so it might be a minute or two.
Take your time. You're the most important one in this gathering today. So,
I tell my court reporter that she acts like she works for me, and really, I work for her. It's just the way it is. They act like they try to pretend like we have some kind of control. Everything stops if they're not there, right? So,
Yay for the court.
yay.
I'm here and I'm ready to go. If I could get a case caption even after the hearing, that would be great because I don't have anything in front of me.
great. Why don't you email Morgan Adams, Adams at courts.mi.gov, and she will send you a caption.
Thank you so much.
Sure.
And it looks like everybody's here. So,
Great.
Your Honor, if
So
you're ready.
I'm ready. I'll call the case.
Perfect. I am.
This is Outside Legal Counsel, PLC versus Michigan Department of Agriculture and Rural Development. It's Court of Claims number 2243 MZ. And we're here this morning because I needed some help with this motion. So I'm going to tell you, I'm going to give you move it along a little bit by telling you where I'm struggling and what my thoughts are. And then I would really appreciate it if you would both help me, both attorneys, and you'll have a chance to put your names and appearances on the record too. So it seems to me that the state's personal privacy exemption claim is not very compelling, Ms. Zilgit. I'll just tell you that, in part because there's a wonderful, if you haven't read it, I really commend you to read a U.S. Supreme Court case on the personal privacy exemption. I realize it doesn't necessarily apply, but I think its reasoning is very persuasive, called FCC versus AT&T. And it happens to be a case I teach my students at Wayne every semester, so I'm very familiar with it. It's a Chief Justice John Roberts opinion on the FOIA, on the federal FOIA, and whether the personal privacy exemption applies to corporations. And he clearly says no. And I'm persuaded by that reasoning. And if I had to reach the personal privacy exemption here, I would probably construct an opinion that pretty much echoes the reasoning of Chief Justice Roberts in that case. But I am struggling, Mr. Ellison, with how you get around the other exemption that the defendant cites. That is the portion of the trade secrets or commercial or financial information, because it seems to me to be commercial information, but maybe I'm wrong. It's not trade secrets. It might be financial too. But anyway, the point is that it says the information is submitted upon a promise of confidentiality by the public body. And the state has given us this letter written by Gary McDowell, the director of the Department of Agriculture and Rural Development, which seems to incorporate a promise of confidentiality. So, and the other thing, Mr. Ellison, maybe you could address is exactly what you're looking for, what you want the state to produce here. So with that, I'm done talking and I'll start listening.
All
So,
right. Well, I kind of suspected this is kind of your MO to start each of these hearings to tell us where's Phil's tripping up on something, right? That you want some answers to. So, oh yeah, parents,
Can I get your appearances?
parents,
please?
yeah.
Thank you.
Philip Ellison appearing on behalf of Outside Legal Counsel PLC.
Thank you.
I don't know if you, Emily, if you want to do yours right now.
Sure, thank you. Emily Zilgett appearing on behalf of the Michigan Department of Agriculture and Rural Development.
Perfect. Thank you.
All right. See, that's, I just said, she's in charge, right? We go right back to where we started this morning. So, Judge, I guess where I would start so that we're all on the same page, if you have, I assume you have the papers in front of you. If we could
I
pull
do.
up Exhibit F to my motion.
okay, give me a
It
second.
should be the
here.
ballot is what it should be, of the blank.
Yes, I
ballot.
have the ballot.
Okay.
Yes,
right.
definitely have the ballot.
So Exhibit F, what I'm looking for, and as my opposing counsel has been clear about, I made three requests within the same document. Two of them are not at issue in this case at all. So we can just set those aside. But I think there's an important detail in that, though, as one of the disclosures that the department gave me, and that's Exhibit G, is the list of everyone's names and addresses. So
Right.
this kind of ties into, and not to take advantage of the fact that I'm counsel in another case with you, but in Ahmad, right, University of Michigan, we kind of have that same thing with the public domain doctrine. Once you've released that information out to the public, you don't get to redact it elsewhere and claim an exemption elsewhere, which that normally comes into the privacy aspect. So I guess, but I don't want to get too tied up in that, but I guess the point I wanted to make is the government has already given us the names of all the retailers. So
But let me stop you for a second,
Yep.
but they didn't give you their votes. They didn't give you their how they voted. And that seems to be the promise of confidentiality here.
I'm building crescendo to that here is what I'm doing here
Okay.
this morning.
All
So,
right.
and the reason why I say that, and that's why I want to go back to the official ballot. If you look at it, there's 4 sections to that ballot. So in any FOIA case, the obligation of the government would be is to redact only that portions which are redactable. So if you look at, for example, paragraph 1, right? That information has already been made public, the name of the actual retailer. So they would not have a basis. At minimum, they should have provided me the 65 ballots with at least the names of the retailers that actually made the vote. Now, I know that's hyper technical right now because I want to get to the most important part, which is paragraphs 2 and 3 of that ballot, which is exactly where you were, hurrying me up to get to here this morning. The problem that I see right now is, and I would point to the case I think that you should help control you in this case, again, pulling onto a federal case, is Gulf Western Industries. And what that case, it's a federal case, and we both, my co-counsel and I, my sister counsel and I, are in the same predicament. We have very, 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 and I underlined very, little case law about this exemption under Michigan precedent going forward. So we don't have a lot to help you with in terms of prior cases. But I think if we adopt that standard from Gulf Western Industries, I think that's the controlling intent of the legislature to say what constitutes first step, what constitutes, and again, they setting aside trade secret, because I think they waived trade secret. They didn't insert that any further. What constitutes the coverable commercial or financial information that's been provided to an agency for use in developing governmental policy? The example that I think of when I hear of this, it would be, for example, I know there's a program here in Saginaw County that says we're going to put a tax, a local hotel tax on hotels. And we want to know how much tax we should probably raise because we want to raise X amount of dollars. So we're asking local governments local hoteliers to come in and give us how many rooms you rent, at what rate you rent, how many customers you have, that's the kind of financial data that would, if released, could provide a competitive advantage if their competitors got that information. They could adjust their pricing, they could adjust their quantities, they could adjust the sales or promotions or whatever to try to essentially use access to that information to get a competitive edge in the marketplace. If we look at paragraphs 2 and 3 of the ballot, what information's there that even if they were to reveal that would provide that competitive edge? And that's where I point to the Gulf Western Industries as the standard, because the standard they adopted there was it's only that information which is meant to that was meant to be protected, was to protect information that, if revealed, would cause a substantial harm to the competitive position in the marketplace. I don't see, to me, how whether they voted yes or they voted no on this actually helps or hinders them in the competitive marketplace. Because regardless of how they voted, the assessment applies equally across everyone. Now, I will say, and of course, I'm always in a kind of a pickle when I get into these kinds of situations, because one of the things judges invariably want to know, because judges are human like the rest of us, is why do you need this information?
No, I don't care. So luckily you have a judge who really doesn't care.
No,
about
I appreciate
that.
that. I mean, and that's the point, is Taylor versus Board of Water and Light says the reason's irrelevant, right? So
right. And I take that to heart. I don't care.
So the problem here is that if I say that just because I can represent to you that I am not seeking this information on behalf of somebody or for someone to give them a competitive advantage. And even if I was, how does the fact that they are one of these retail propane marketers, because number 2 has already been publicly disclosed by Exhibit G. It's the list of all the ones that actually do provide that. So really the only paragraph we're really talking about is, and again, I know I'm kind of crescendoing up to this, is paragraph 3 of that ballot, which is the vote itself. How is that vote itself? You have to get through the first threshold question is does this constitute the type of commercial and financial data? It's certain, I don't think it's financial to the company. It's certainly financial in that it deals with dollars, but it deals with what assessment the government is going to place on the wholesalers, that will ultimately be paid by the retailers in this respect. And whether or not that information is disclosed will not, I don't even see how it harms, let alone significantly harms, the competitiveness of one retailer to the other. So I don't think you need to get to subsections, and I don't have it in front. I don't know if it's 1, 2, 3 or ABC, whatever the 3 follow-ups to that, because this doesn't constitute the type of commercial and financial information that would be protected by this particular exemption. Now, let me add one. Oh, I'm sorry, go ahead.
No, I mean, what I'm thinking about now is it's definitely, it seems to me it relates to commercial or financial generally. Let's skip the word information for a minute, but I'm wondering if it's really information. I mean, it's a vote on a policy. Is that information? I don't know. I mean, I was just thinking about that for the first time as you were taking me through this.
Well, the statute, let me just pull that up, because the statute does use the word information in there.
Does it? I have the statute here too. Does it have a definition of information?
It does. It says no, it says.
No, I'm looking in the definition section.
Okay.
But no, I don't think it does.
I don't think it does. I'm not recalling that off the top. I would have looked at that. I'm certain I would have looked at that if I would have been. So the statute provides as trade secrets is one, as I read it, or commercial or financial information. So as I read this, is that this is trying to seek the information, business information, business financial data. And what?
Oh, wait a second. Let's stop here. I don't want to do your work for you, but this is if I accept, and I probably do accept that, number one, they've already revealed. I mean, number one has been disclosed. We have the list, so that's not personal information anymore, and their names are not commercially protected.
Yep.
Number two, I certify that I am a retail propane marketer. Well, that's pretty much subsumed in the list that they already produced too. So I don't see how that's already been provided. They've waived any exemption on there, or it just doesn't exist. But to me, it comes down to number three.
I agree.
Which is a question. Shall the Michigan propane marketers approve the initial assessment on propane at the rate of 1/10 of 1 cent per gallon, blah, blah, blah? Well, I don't know. I'm thinking now, is this information? I mean, this is certainly an opinion because it's a vote, but I just don't know if that, and it is commercial in the sense it relates to commercial transactions. I'd be hard pressed to say it wasn't commercial, but I guess what I'm struggling with now is this the type of commercial information that the legislature intended to be able to allow a public body to shield with a promise of confidentiality. Look, I think that, your hotel example is well taken. I think that public bodies probably do solicit commercial information all the time, so they can, with the promise of confidentiality, so that the legislature and our administrative state can develop some regulations and some laws that will enhance and encourage commerce. I get that. But I'm just not sure that this is the type of information. I'm not sure it's information in the first place that's intended to be subsumed within this exemption.
Not to, I know you're never as a judge, you're always pushing me all the time on these details like this. And of course, I guess I've never thought of it that way. I guess how I analyzed it in my mind was, is this information, like the hotel example, is this type of the information? Because, and this ties me into the policy argument, the very short policy argument I'm going to make, in that FOIA was designed to give access to the way government operates and those who represent them in government, is the language from the preamble that's at the beginning of this of FOIA that everybody always cites at the beginning of the kind of the long list of standards with FOIA. The legislature delegated the decision of the government of assessing this particular amount of special, tax assessment or propane assessment or whatever. It delegated that governmental decision-making to a group of retailers. So really, these folks, and this is the part I think may have gotten missed when we were briefing, is I'm not arguing that that the propane retailers are legislators, but they're certainly policymakers, because they have been delegated the authority to make the decision that will affect the 1 million propane users in the state of Michigan. And so in my mind, I don't view paragraph 3 as a question of private business enterprise. It's a governmental question that's been delegated to them. Now, fair enough, as Ms. Zilgett points out, they're not required to vote. And I agree. I don't dispute that. But for those that decide to exercise the function of government that's been delegated to them, this is effectively a tax. A tax is a government decision. They've delegated that job to them, and the FOIA is designed specifically to get the information of the actions of those who represent them. And in this case, these are the 65 ballot voters that decided to vote to impose this tax. So I only say that not to stand on a high horse with this, right? But simply when you read that context of what the information, even if I understand not whether this is even information, but let's just assume this is the kind of records that the state is attempting to how do I want to say it? Let me start over with that. I guess the point I'm trying to get at is when you look at this particular type of information, this is not the private government or private business data like the hotel example that's being offered to help formulate the policy for someone else to make the decision on. It is actually the delegation of the decision itself to these individuals. It's unique. It's very few, there's very few areas of the law where the government has delegated the authority to decide governmental policy to somebody else in the private sector. And that's what they did here. And because of that, I think, at least as I take it, if you use the Gulf Western Industry Standard, there's nothing in answering paragraph 3 that is going to give a competitive edge to one of the propane retailers over another, because they're all subject to the exact same assessment that's been decided upon to be implemented in these circumstances. So in that respect, I don't view this as financial or commercial information of the retailer. It's actually information about the government's decision-making in that respect and how they came about to get there. And under FOIA, as a FOIA requester, which is, and of course I get something, the humor of the fact that I myself am the requester on behalf of my law firm, I'm entitled to that information to understand how the government operates, because I have concerns, and I'll be a little more forthright with you. You say you don't want to know, but I'll take the next step is I think there's a problem here in this program, and I'm investigating it. And I am entitled as an entity, which a person under FOIA is a LLC is a person. I'm entitled to the affairs of government and those who and the decisions of those who represent them. And I'm entitled to that information. And so I guess that's where I come from when you say in this promise of confidentiality. And well, I want to get to that in just one second, if you'll bear with me, Judge. But I guess the important part is I don't think you got to get through the first threshold question. You don't need to get to the tougher confidentiality questions. Now, if I can shift gears, set that aside for a second. One of the things I guess maybe can help enlighten me today is Ms. Zilgett, in her response, wasn't real clear on whether or not these ballots were MDARD records or are they commission records. At different points, she takes different positions, at least impliedly in different spots, because if they are commission records, the problem is that under the standard, the promise of confidentiality has to be by the chief administrative officer of that public body. And department head, I don't know what they call him now. I don't know, the head of MDARD, Mr. McDowell, is not the chief administrative officer or chief administrative official, I should say, of the commission. He's the chief administrative officer of MDARD. So if these are in fact commission records, that the three follow-up, the conditions on financial and commercial information would fail, and the burden would fail in that respect. So I get at a certain level that knowing how somebody votes is an unusual concept. But if you think about it, every vote, quote unquote, vote you make is a public record. Every vote the legislator makes is public record. Every decision of the executive branch is usually public record, or at least FOIAble in that respect. In this instance, where the government has delegated that task to a handful of private business owners, that is accessible information to understand the affairs of government. So that's my thrust of my argument, of the notes that I have on that section. I, of course, as always, I'm always happy to answer any further questions, but I think you've got the thrust, and I hope I've convinced you, or at least made things more difficult for you to make this decision today. So
as usual, you made it more difficult. So let's hear Ms. Zilgett. Maybe she'll make it easier.
I hope so. Good morning, Judge. There's a couple things I'd like to unpack, and I'll start with just if we could look at the ballot again. And we were going through the names and the boxes 1 and 2. And I did just want to point out that, Mr. Ellison had said, at the minimum, we should be providing the names of those who voted. And I did want to point out that I think it was something like 115 ballots were mailed and those names were provided, but not everyone submitted a vote or cast a ballot. So there is a concern here that when you're saying who voted, that you can deduce how they voted by naming who voted, because you can obviously figure out who didn't vote. And there is a detailed summary, and I think it is Plaintiff's Exhibit E, the opinion and order of the director, that discusses, of the 65 ballots received, 49 voted yes and 16 voted no. So, and I also want to point that out as, this is not a situation where, there's no information about how this referendum was done, or, it's entirely done in secret. What isn't known is how each individual retail propane marketer voted, but the details otherwise are there. How the referendum was conducted is there. How many ballots were issued is there. How many returned is there. How many voted yes is there. How many voted no is there. So this is not like a secret procedure that no details are known. So that is the concern. Also, I don't believe Mr. Ellison ever specifically said I would take just the names of the individuals who voted. But regardless, there is that concern about still being, that information you'd be able to deduce who voted and how they, or by knowing who voted, you could say, okay, if I just figure out the 16 who voted no, now I know who voted yes by having that information. Moving now to maybe the more substantive legal parts. Mr. Ellison has asked for adoption of the Gulf and Western Industries standard, and we would disagree with that. Obviously, there is one thing that Mr. Ellison and I agree on. There's not a lot of case law on this exemption, and we do agree with looking to federal courts. We think that's appropriate under FOIA. We think that's appropriate here, but there is a little bit of a distinction in the federal exemption. The federal exemption has 3 elements. The information, or to be exempt, it must be commercial or financial, obtained from a person outside the government, and privileged or confidential. The Gulf and Western Industries case actually deals with that third part, whether the information's privileged or confidential. And that is not an element in our statute. And there's also, that case is from 1979. There's a 2019 case that from the US Supreme Court that I believe is a Justice Gorsuch opinion that kind of gets rid of that substantial harm element as to the confidentiality. Anyway, I can give you that citation if you want, but
yes, do.
Okay, yeah, it's food marketing industry. The citation is 139 Supreme Court 2356.
Thank you.
And it talks about how where there's commercial or financial information is customarily and actually treated as private, then it's confidential for purposes of the FOIA. But again, I'm not sure that's all that relevant because that's not actually an element under our statute. The federal statute is a little different, but on the commercial or financial prong of the federal statute, the case law under federal courts really gives it just a, we put this in our brief, a common sense approach. Is there a business interest in this information? Is there a financial interest in this information? And we would argue that yes, there is, that the vote itself is information. They're providing information about whether this assessment should be levied. It's about about propane that's placed into commerce in Michigan. It's an amount, it's a 1/10 of 1 cent on all.
But isn't there a difference between information and an opinion? I mean, if I vote to approve a colleague's opinion, if I say I approve your opinion, is that information? I mean, that's my opinion. What have I communicated other than my opinion? That somebody else's opinion is right.
mean, this almost feels very philosophical. I do think that that still is information. I mean, information to me is very broad. I mean, I don't have an actual dictionary definition in front of me. I mean, I think it's important that the statute doesn't say records, you know, it's not saying financial records, it's not saying commercial records. So I think information is meant to be more broadly construed. And I'm not sure that they are just giving an opinion here. I mean, I think that the vote itself, you know, can be construed as commercial information. They're saying, you know, yes or no is a type of information. I mean, saying yes or no as to levying assessment is a type of information. And I think that we can also, you know, some of the federal definitions that we cited to in our brief, I think could support that also. Just looking at, you know, is there a business interest, like kind of applying a common sense approach. And I think that there certainly is a business interest in whether these companies voted and how they voted on levying the assessment.
How do you respond to Mr. Ellison's concern about whether the person who signed the letter falls within the statute's statutory language requiring that the chief administrative officer of the public body be the one who promised confidentiality?
Yeah, and I apologize if there's any confusion there. I think the distinction we're trying to make is that the retail propane marketers aren't a public body, but the MDR director by statute is the one who conducted the referendum, and these are public records housed within MDR. You know, MDR doesn't otherwise keep the propane commission's records. The propane commission is a separate body, but under the statute, the MDR director had to conduct the referendum. He did. These are a public record as defined by the statute. I didn't mean for there to be any confusion there, other than just that this statute didn't turn retail propane marketers into some kind of legislative body. And to that point, also,
let me stop you for 1 second, because I want to be sure. So is the Michigan Propane Commission a public body?
The Michigan Propane Commission is a public body. It's subject, or it's at least subject to FOIA by statute. It's subject to the Open Meetings Act by statute. It's subject to FOIA by statute.
Okay, and so Mr. Who is the chief administrative officer of the Michigan Propane Commission? Is it the guy who signed the letter, or is that not who it is?
That's not who it is.
Okay.
But I would just clarify that the Propane Commission was not holding the referendum. The MDR director, who is Gary McDowell, was holding the referendum, and that's why he issued the letter. And I could find that statutory provision that requires him to hold the referendum.
I'll find it.
Oh,
thanks, though.
Yeah, it's also, I believe, in our brief.
I think it's in your brief too.
Yeah. To the point, though, about the delegation and, you know, whether this assessment is a tax, these so-called commodity entities, these are not actually particularly new. And the Supreme Court has actually looked at a different commodity entity. I mean, I don't necessarily think we need to get into this, but I think every crop or, you know, interest that Michigan has a similar, you know, there's a cherry commission, there's a carrot commission, there's a potato commission, there's an asparagus commission, there's a, I mean, I'm missing some, but if you, there's a wheat. I mean, I think if there's a crop in Michigan, there's a commission on it. And there's the Agricultural Commodities Act, which was actually considered by the Michigan Supreme Court in 1979. Under issues about whether the assessment was a tax and whether it improperly delegated authority, legislative authority to the producers. And the Supreme Court ruled, you know, in the negative on both, that it's not a tax and that it again, this is a different statute. It's the Agricultural Commodities Act. that it's not a tax and that it did not improperly delegate authority. Again, I don't necessarily know that that's relevant to the FOIA question, but because, Mr. Ellison has brought it up, like that this is a tax, I think that it's worth pointing out. I do have that citation in front of me if, we'd like to talk about it. That's 405 Mish 1. It's the Dukeshire Farms case. I'm not sure how to pronounce that.
Okay, I don't have any more questions for you, but I think Mr. Ellison probably wants some rebuttal, knowing Mr. Ellison.
No shortage of talking there on my part. I'll take every second I can get. So I just want to be clear. I don't want to tie this up into whether this, and I think Sister Counsel agrees with me on this, is I don't want to tie this up as whether this is a special assessment or a tax or whatever label we want to call it. I think that's whatever we want to call that is largely irrelevant, because whether it's something's a tax or a fee, that's got some constitutional considerations about whether, whether there has to be a vote of the people and all this other. We don't want to get into that. All I was trying to get at is that the ability for the government to extract money like a tax or like an assessment is a governmental function. It's not something a private enterprise. Private enterprise does not collect taxes from each other. So the whole point I was trying to make is the activities that was being voted on by the private retail propane marketers, it was a governmental function. At least I think it's a governmental function. And that was the only point I was trying to make with that respect. And that's why I think understanding that kind of viewpoint makes the trade secret / commercial financial information exception put into its proper context and its proper spot, because this is not like the hotel example, right? The propane marketers are not supplying information about how much propane they're selling or what price that they're selling it at, or any of the things that if another competitor in that same market got that information, could use to their financial or competitive benefit. The question here is simply one of, are we going to, with the power that's been given to us by the Propane Commission Act, decide to direct the government to begin collecting this assessment? Because again, the propane retailers don't collect this fee. The commission does. And the commission is the one that collects this. And if you want a whole deep dive into how these go about doing it, the statutes there, and I'm not going to bore you with that today, but it just to say is that the commission itself is the one that actually collects that tax. The government collects that tax, and the commission is a body within the Department of Agriculture and Rural Development that way, subject to FOIA, subject to Open Meetings Act. Like Sister Counsel indicates. I guess the last point I would get at is I'm always hesitant to say to you, adopt a particular court case in the FOIA context by looking to federal precedent, because it is true, and I agree 100%. And in fact, this came up, I think, in the Hamad case too. It's hard to compare the Michigan FOIA and the federal FOIA the same way, because they have different language, they have different ways to go about it. But I'm only offering Gulf Western Industries as a potential standard. I don't know, I actually don't even agree with everything that's said in that decision, but I do agree that the standard by which the commercial information that was attempted to be protected by this exemption, which the federal FOIA has a parallel one, is just to give the context of what type of information, to separate this unique circumstance of the government delegating and giving the retail propane marketers the vote of the state effectively, versus those circumstances like the hoteliers who are giving actual private business data to help then formulate the policy that someone else decides. Other than that, I guess unless the court has any other questions, I guess I want to be clear. I think, and I'm not trying to be facetious, but I think Ms. Zilgett just confirmed that the ballots, at least from their position, are department records, not commission records. And if that's the case, then Director McDowell would be the one who would be the chief administrative official for that. But I'm not quite sure we even heard that was conceded to or not, or if that was, that may be something that may come up that the court may need additional information on. But
that's what I think I heard too.
That's what I took it as, but I don't want to be presumptuous in that respect, because the difficulty here, again, this act is and I'm going to use the word weird, is that it's got a department agency overseeing a commission. Both of them are public bodies, but yet the records of the commission are not necessarily the records of the department. So it's a bit of an unusual, and that like a state agency is overseeing this group but does no more. The actual tax, special assessment tax collection is not something the department does. That's something that the commission does. So it's kind of a weird interaction between the two of them, but to the extent that I think personally, I'll just say I would agree that I think these are department records. I do. I think we're in agreement on that. And that at least that clarifies it. So I think that to me, where I've kind of planted my flag on the hill to plant my flag on here is what constitutes commercial and financial information. And of course, I'll tag on to your arguments today, Judge, and maybe you need additional briefing on whether this constitutes information or not. I struggle because
I don't need more. I'll do it. I do my own research. I'll figure it out.
Fair enough. So unless you have any other questions, Judge, I think you've gotten my position here today, and unless you have any other questions, we rely on our briefs.
I don't. And Ms. Zilgett, I know technically you don't have the last word, but if there's something that got said that's incorrect that you want to fix, please, this is your opportunity.
No, Judge. I think there's some intricacies of the Propane Commission Act. I don't really think it's actually relevant. Just the wholesale, there's a difference between wholesale propane marketers and retail propane marketers and how this collection works. We're probably getting in the weeds of, what the FOIA is, and I don't think it actually, ultimately matters, and it's all ultimately in the statute. So, what Mr. Ellison and I say probably is just reiterating the statute, and Judge, you're very capable and can look in the statute. I'm also happy to answer questions, but I don't think we need to really get more in the weeds of the Propane Commission Act than necessary.
I think you've both been very helpful. I think I'm glad we did this argument, and I'll get to work. And I think I would like a copy of the transcript. So if that's okay, Ms. Maida, we'll order it.
Judge, will you write a recommendation for Emily and I to be on the Asparagus Commission?
Sure. Or would you prefer asparagus or potatoes or carrots?
Potatoes, carrots. There's an onion one. There's an onion one out there.
Asparagus is my favorite vegetable. So
can we go off the record on that?
Oh yeah.
Sure, we can go off the record. Yeah, this is all off the record. So.
Thank you. Thank you. I do have one question. Is it M-Gard? M-Dard?
Dard. Yeah, D-A-R-D.
That's what I thought.
Yeah.
And then I need, between the attorneys, who is taking the copy? Obviously, the original goes to Your Honor, but
right.
Who will be ordering the original and who will be the copy?
I don't need a copy.
I'm probably the only one ordering it, I would guess.
All right, very good. Then I'll just talk to your office about that.
Right. Yeah, they'll pay for it. So
okay. All right. And the attorneys don't need a copy.
No, I'll reach out if we ultimately need a copy. As of now, we don't.
Perfect. And I'll just send out my information to both counsel in the event it happens. You can call me.
That would be great.
Thank you so much. I'm all set.
Thanks, everybody.
Thanks,
Jake. Have a great day. Go eat more asparagus.
Yeah.
Okay.
Thank you.